Okay, well, welcome IFA friends, and my name is Mike Lehman from IFA Government Relations. Thank you for joining us on this date, which is Thursday, March 14th for archive purposes. And we are pleased to bring you today's IFA webinar on understanding the new regulation on independent contractor status. So thank you again for being here. The U.S. Department of Labor published a new regulation on how to analyze who is an employee or independent contractor under the Fair Labor Standards Act earlier this year. And this final rule became effective on Monday, March 11th, earlier this week. And we are here to tell you everything that franchise people need to know about this new regulation and strategies you should be thinking about moving forward. And on today's program, we will also review the results of IFA's annual survey of franchise brands, highlighting economic issues facing franchising and other current trends relevant to our discussion today. So a few other announcements before I introduce our two good friends and expert speakers today. First, on our next slide, thank you to our sponsor, Paychex, for their support of today's program and all their expertise. And second, today's webinar is being recorded. The recording, this slide deck will both be available on IFA's community site later at community.franchise.org. That's community.franchise.org. So make a note of that, share this program with your colleagues because this subject matter should be evergreen for the weeks, if not months to come. And third, we'll be happy to take your questions. Probably at the end of the program, you can enter your questions at any time through the Q&A function on your Zoom screen, and we will pose as many of the questions as we can to our experts. Okay, now it is my pleasure to introduce our two expert speakers today. First, we have Allison Stevens. Allison is Senior Director of HR Services at Paychex, based in Boston. Paychex, of course, is a leading provider of integrated human capital management solutions for payroll, benefits, human resources, and insurance services. And they pay 1 in 12 private sector American workers, and they are a preferred IFA vendor. So welcome to Allison. And we also have Brian Schnell, who is partner at Faegre Drinker in Minneapolis. Brian represents franchisors and has over 30 years experience counseling clients on all matters dealing with franchising and product distribution. Brian's firm wrote IFA's official comments to the U.S. Department of Labor on the independent contractor proposed rule back in 2022. Welcome, Brian. So before we get to our speakers, it's actually my pleasure to bring you the results of the annual IFA Frandata Franchisor Survey to set the discussion here before we turn it to Brian and Allison. So this is the third year that we've done this franchisor survey. And one of the things Matt Haller has really aimed to do is develop more benchmarked, original, research on behalf of the franchising community. And here's high level what the survey found. First, the number one business challenge for the third year in a row is the cost and quality of labor. We're all in a worker shortage. We know that, very relevant to today's subject matter. 80% of franchisor respondents reported their franchisees have unfilled job openings, and qualified applicants increased slightly in this past year, with 54% of respondents saying that they have qualified applicants versus 42% last year. And on the next slide, the labor pressures remain very significant and have really since the pandemic. There's a few new emerging issues in this third bullet that really highlight some of the things franchisors are thinking about today. It says the emerging challenges for franchises heading into this new year include the cost of capital, and some waning consumer demand. And those are new issues that we haven't seen as much coming out of heading into this rising rate environment post-pandemic. Okay, so that's a summary. Let's get into this next slide and the findings of the report. First of all, here's a distribution of the respondents, maintenance services, quick service restaurants, gyms, hotels, child-related franchises, and then sit-down restaurants led the way in our responses, but a great distribution across our diverse franchising community. On the next slide, it shows that a total of 215 brands responded, and a great diversity in terms of their system size and employee size. On the next slide, let's get into the results. So mentioned labor and the worker shortage has been the top concern of franchisors and franchisees over the last 3 years since this survey was begun in 2022. So the cost of labor continues to be the top concern of franchisees, according to their brands. So everyone is continuing to struggle to find people to fill their growth plans, although that worker shortage issue has been mitigated a bit each of the last 2 years. So perhaps that's some good news, although I think we all know the workforce may be permanently different coming out of the pandemic, and that's reflected with these findings. On the next slide, mentioned qualified applicants are a big concern. Despite the labor market, qualified applicants for job vacancies increased slightly last year. So that the last 6 months, you see on your screen the number of qualified applicants continues to be a top concern in this labor market that are available for franchises. On the next slide, because of the tight labor markets, we've seen some real growth in wages as well in response. And according to this year's survey, wage growth last year was higher than even anticipated. 81% said they increased wages in the past 6 months, and another 61% were planning over the next 6 months to increase wages further. So wages still going up, perhaps slowing a bit year over year based on those responses, and we'll continue to track whether the labor market reflects that reality. On the next slide, this question asks, to what extent would you say labor challenges currently affect your growth? Is the ability to find workers hampering your growth plans? Significant that only 22% perhaps said it's a considerable constraint compared to 37% a year ago. Still 51% said it's slowing growth somewhat. So a very sizable majority of 73% of franchisors said there's still an impact on growth and the inability to find all the workers they need. Only 24% said the availability of workers is not a factor in their system's growth plan. On the next slide, franchise businesses are aiming to address the worker shortage by prioritizing efficiency and new technologies and really selling, leveraging the value proposition in franchising. These two questions asked, in what ways have your franchises attempted to address their labor challenges in the past 6 months. You see some of the responses both over the previous 6 months and next 6 months. We talked about increased wages on the earlier screen, increased efficiencies, and technology continue to be ways that franchise brands are looking to help franchisees with some of their hiring issues. And then on the next slide, a little more on technology specifics. You see in these blue bubbles some of the specific examples of what franchisors are doing to help their franchisees. Just to read through those, artificial intelligence, labor analysis and scheduling tools, developing tools that allow workers to take on additional responsibilities, use of software for various administrative tasks, and more references to automated tools in areas like marketing. So we see obviously a trend where workers become hard to find and jobs are hard to fill. Technology is increasingly where employers are turning to create efficiencies necessary to operate. And on the next slide, more on technology. This question said, looking ahead to the next 6 months, how do you expect your capital allocation to technology and innovation in your franchise system to change? 73% in response to the worker shortage said they will continue to invest more, not less, or even the same in technology. And, you know, this is the franchise value proposition. And again, why you go into business in a franchise with a brand partner, a network of franchisees to bounce ideas and best practices off of and leverage all the resources. And we see franchisors increasing their investments in their franchise owners and people. And then on the next slide, one more question on are you planning to increase, decrease, or maintain your current marketing spend? Again, an increase to 60 by 60 described by 62% of respondents. They will continue to increase their marketing spend. Next slide. So with regard to workers, we asked franchisors, do they expect their capital allocation to training to change? Again, strong majority, 57% of brands say they're going to spend more money on worker training and development. And so in terms of retention and keeping the workers and star performers that they have, franchisors investing in all sorts of ways. And then on the next slide, additionally on training systems, this says, are you planning a complete overhaul or no real changes to your training programs? You see a majority here continuing to update their training programs. That probably makes sense. And continuing to stay current with existing workforces in the current labor market. And on the next slide. I think this is the last one, relevant to sort of a cousin issue of the independent contractor status issue is the joint employment issue in terms of liability between franchisor and franchisee. We see the lawsuit won just over the weekend, defeating the National Labor Relations Board joint employer rule. That lawsuit led by IFA and a big victory, at least temporarily, but certainly for the foreseeable future for franchising. We did ask over the winter franchisors' view of the joint employer issue and their concern with the prospective rule at the time when we asked about 2 months ago, what is shown on the screen. 74% of franchisors will have a high level of concern if they need to take more control of franchisees' day-to-day operations and another 67% said they would be concerned, about reducing operations and compliance support if that was necessary under the rule. Thanks to the lawsuit decision, we don't have to deal with this right now, but I just mentioned that other aspect. Okay. Excuse me. You are welcome to see the entire franchisor survey. If you get your phone right now and click on the QR code with your camera, you can see the full results of the third annual IFA Franchisor Survey, and all these results. Certainly incorporate that into your materials, and you can also Google it, 2024 IFA Franchisor Survey. It should come right up beyond the QR code. Okay, with that, it is my delight to yield to the chair of the franchise practice of Faegre Drinker and our good friend Brian Schnell to tell us what we need to know about this new independent contractor regulation. Brian.
All right, thanks, Mike. Good afternoon, everyone. Delighted to be with you all and talk about something that is meaningful and relevant to all of the stakeholders in franchising, franchisors, franchisees, and the suppliers that work and support franchisors and franchisees. Let me just start with a comment about what Mike just shared regarding the survey and franchisees identifying, or franchisors noting that one of the main concerns that their franchisees have, those concerns relate to labor, staffing, wage issues. That remains a key challenge. It has been for a few years, and it'll continue to be a challenge. It's all about, franchisees wanting to find, keep, and reward employees. And with this joint employer and independent contractor rule, what remains is some franchisors saying to their franchisees, sorry, we can't get involved in your labor, staffing, wage issues because of these concerns and the legal counsel we're getting. So that can lead to frustration. And so how do we navigate in this current world and environment on being a strong franchise business model, both franchisor and franchisee? And so that's part of the conversation that we're going to have today. Because I think, to Mike's point about if franchisors are concerned about taking more control over their franchisees' day-to-day ops, I absolutely agree. That would be disastrous. And that's not what anybody intended in getting into franchising. So how do we navigate, again, these kind of common threads that appear with joint employer and independent contractor classification, misclassification issues? There's two main threads in my view. One is control. It's all about controls. We often in franchising talk about controls in the context of brand standards or system standards. So we're going to talk about that. And then clearly a regulatory overreach and a failure to understand, although IFA and lots of you are doing phenomenal work in getting the word out to regulators and politicians, but there still is work that we all need to do to get rid of this overreach and have more people better understanding the essence of franchising and the business model. So just a few other initial thoughts on this DOL independent contractor rule. Interestingly, they asserted in their comments that workers primarily classified as independent contractors before this rule in 2021 will likely continue to be properly classified as contractors based on the common law and past precedent. I guess we'll see in that regard, because many don't have the confidence in how the DOL specifically is going to handle these issues. And so we'll need to be mindful and diligent. And now is the time to take a fresh look. And Allie's going to talk a little bit about what we all can do on this independent contractor audit, for lack of a better term. But now is the time to double down on taking a look at what you're doing and what changes can be made that doesn't overthrow the apple cart, because I don't think we need to do that. But I'm convinced that most franchisors can do some things to reinforce the franchise business model, that our franchisees are independent contractors, and that our franchisees are the employer of their workers. And then for franchisees who utilize independent contractors, it's important for them also to make sure that how they're employing or engaging workers is properly classified, because classification matters. Employees have protections under the Fair Labor Standards Act that independent contractors don't. And so with this kind of new, if you will, totality of the circumstances standard with especially with the DOL and the Biden administration on pro-employee, pro-worker focus, getting this right and understanding how to minimize risk and liability is really, really important. Let me also share, there's no express, although, as Mike noted, on behalf of the IFA, we submitted comments to the DOL in the rulemaking process, and we expressly asked for a carve-out for franchise relationships. We tried to educate people who were looking at this submission as to the importance of the franchisor-franchisee relationship and what that really means to business. But there's not an express carve-out for franchise relationships. And it's really those franchisors where the franchisee is a franchise owner that performs the work personally. Those types of businesses are probably more at risk and really should undergo the type of analysis that we're going to talk about today, because those systems likely are at a greater risk than larger franchisees that have dozens or more of employees, and the franchisee's not in the business every day, but working on the business. So, and again, we've talked a little bit about the NLRB joint employer rule. And so let me just share that the independent contractor classification rule probably carries less risk for most franchise businesses, as I just noted. But it's clear that the DOL is placing more emphasis on things like pricing and customer standards as evidence of employee status. So again, there's this overall regulatory trend that is more hostile to the franchise business model. And it's why we all of us need to lean in looking at our businesses, but also doing everything we can on the regulatory front with politicians to make sure that they understand this, and with judges to make sure that judges will take the time if there's a lawsuit on any of this independent contractor classification. All right, so the rule reverts to a multi-factor, we can go to the next slide, a multi-factor totality of the circumstances and economic realities test. And these factors have equal weight. So one's not any more important than the other. And so judge, a court, the Department of Labor should look at these and look at them all equally. And let me just share a couple of insights on a few of these and try to apply it to the franchise business model. So this first factor, opportunity for profit or loss depending on managerial skill, the rule specifies things like the ability to negotiate pay, decide the order of jobs, hire workers from outside. That indicates independent contractor status. So they truly are business owners and not just doing the business. This second point, investments by the worker and potential employer. Again, that's we all talk about the investment that franchisees make to own and operate their business. It's that capital involved. It's the entrepreneurial spirit in franchisees wanting to own and operate their own business. The concern, though, here is for franchise businesses with low startup costs. And again, there's nothing wrong inherently with those businesses. And we have a lot of franchise systems where the initial investment is less than $100,000. But again, like businesses where the franchisee is doing the work, franchise opportunities with an investment of less than $100,000 are more at risk of this counting against them in this independent contractor analysis. Let me go to the fourth factor here too, nature and degree of control. Again, I talked about how franchising is all about controls. And so I'm gonna close my remarks with how I view franchisors really leaning in and establishing kind of top line controls that equal brand standards without dictating how franchisees meet the brand standard. And too often, and I still hear it when I walk through trade shows and the like, where franchise salespeople will say things like, "We got it all figured out. This is plug and play. All you need to do is follow the playbook that we have." Have we heard that before? We've heard that before. And so this, to me, this is all about, Mike, what Matt and the entire IFA team and so many others talk about: responsible franchising. It all ties together. And so I think it's a tremendous opportunity to go back to the fundamentals of franchising, because we don't have it all figured out. This isn't plug and play, right? We have a system that we're licensing to a franchisee, but it's their business. And so again, all that feeds into, yeah, that's what independent contractors are all about, rather than an employee. And the other way I see it is where franchisors will say, I'm going to tell you what to do, how to do it, how much you need to spend doing it, and what happens if you don't do it. You know what? That sounds like a little bit like an employee, right? So it's time to take a step back and a fresh look at how we frame some of the controls that are the essence of franchising. System standards and brand standards are mission critical to franchising, but it's how we talk about it, how it appears in our materials, how it appears in our manuals, how our field support people provide field support. All that matters. And again, it ties into points 5 and or factors 5 and 6, the skill and initiative. We want franchise owners that need the whole skill and initiative to drive and grow their own business rather than us doing it for them. All right, those are the 6 factors. But this new totality of the circumstances, there's a twist. And again, it's like full employment for lawyers, because people will say, well, what does that mean? And we don't know, right? So there's uncertainty, which is extremely frustrating. But the DOL and its rule recognizes that these six factors aren't exhaustive, that there are additional factors that they'll consider on a case-by-case basis, but it's really about what is the worker doing and are they in business for themselves. So again, to the extent we can describe a narrative that speaks to that, and we execute on that narrative, and every stakeholder in our system understands that and embraces it, this rule will not be problematic. All right. Next slide, Mackenzie. Okay, so let me just close with what the rule means for us, franchisors and franchisees. And I've touched on this a little bit already, but it's many of the factors that are core to the franchise business model, especially the nature and degree of control, that's at the heart of this independent contractor rule and the joint employer rule. So we need to understand how important that is. And here's the way I often describe it, gang, is it is absolutely appropriate for franchisors to have brand standards, system standards. And I talk about that as an above the line, right? You must meet this brand standard. And again, that's the nature of franchising. That's why franchising works. That's why customers can expect the same product or service wherever they go to a franchise location in a particular system. That's the above the line brand standard. But how the franchisee does that, the manner and means, rather than the top line standard, that so often can be accomplished by, here's a recommendation. Here's some guiding principles. Here are 6 steps that you can consider. But if a franchisee can do it in 4, go for it, right? That's the difference. It's here's the standard you must meet, but how you meet it, that's up to you, franchisee. And that should still allow us to protect our brand standards, deal with franchisees who aren't meeting our brand standards, and yet try to navigate this too much control dynamic that is existing right now in franchise. And to me, again, that's a keen understanding and a reinforcement of the fundamentals of franchising. That's responsible franchising that Matt and Mike and so many others talk about. That allows the franchisee not to shirk their responsibility to be the employer of choice in their market. You can provide tools and resources. And so there are a lot of IFA suppliers, including Paychecks, that provide valuable resources to allow us to navigate these issues and to allow franchisees to be the employer of choice in their market. But the days are gone when the franchisee should ask the field support person for the franchisor, should I get rid of this general manager? He or she's just not cutting it. What do you think about my team? Again, it's being intentional and deliberate on the roles and responsibilities of the franchisor and the franchisee, understanding the difference and helping our field support understand the difference. Many of whom are relatively new to franchising. And so they'll get in a situation where they're helping a franchisee and they'll just say, well, here, let me show you how to do it. Because it's just easier to do that. So again, it's the coaching, it's the mentoring, it's the optional tools, and it's the resources. And finally, and I'll close with this, Mike and Allie, employers, whether they're the franchisor or the franchisee, should consider this kind of worker classification audit. And I know nobody does it as well as Paychecks. So that's how I would close my remarks, Mike, on this very important, but also in many respects, common sense way to take a fresh look at how we can, fine tune some best practices to get the right outcome if we're challenged on these issues.
Thank you, Brian. Hugely helpful. And it's a great thing that we have Allie here, since you set up that her advice and analysis can't be beat on these issues. So thank you, Brian, for zooming us through the rule and what franchisors and franchisees should be thinking about. Now we welcome in Allie to give us some strategy ideas, all sorts of other insights. So welcome, Allie.
Thank you. Thanks so much. Good afternoon. On behalf of Paychecks, really appreciate the opportunity to join you in this conversation this afternoon. Really, really important. So, at Paychecks, we've been tracking the new independent contractor rule really closely. And as Brian just so eloquently explained, when you're looking at the new rule, it's very important to engage a trusted HR business partner, as it may be more likely that contractors could be found to be employees. And in fact, I'll just share a quick statistic with all of you. A recent analysis from the National Employment Law Project report cited in an article just last year that up to as much as 30% of some employers may misclassify their workers. So one area where and if you don't mind, Mackenzie, going to the next slide, that would be great. Thanks. Sorry, I forgot to tell you. One area where we typically see employers struggle is bringing an independent contractor to perform some of the basic core work of a business. And in addition to the Fair Labor Standards Act rules, some states have their own different rules on independent contractor classifications. And even the IRS has a worker classification rule for determining whether a worker is an employee for federal tax purposes. And so for that reason, when we talked a bit about it leading up to now, we recommend that employers do their own classification checkup. That includes reviewing any independent contractor classifications and making sure that employees are properly classified as exempt or non-exempt from minimum wage and overtime requirements. And I'll cover both. I'll share just a few common examples of things we look for as part of that checkup that we're doing with our clients to include our franchisees and franchisors. And you'll see those examples on the right hand of the slide. So hiring a former employee as an independent contractor, and the former employee then does the same or similar work, but now as a contractor. It's as simple as a contractor performing the same work as current employees. And then lastly, contractors that must meet the same requirements as employees. So think, for example, if you're requiring uniforms to be worn, clocking in and out in the same system that your employees are clocking in and out of, having the same access to all facilities and even your technology systems or any systems that you're utilizing as employees. Or lastly, supervising or directing the work of your employees. You can go to the next slide, please. So when considering your employee base, your checkup should also include the provisions under the Fair Labor Standards Act, which require that all non-exempt employees must be paid at least minimum wage for all hours worked and overtime pay at 1.5 times their regular rate of pay. So some positions can be exempt from these requirements if certain conditions are met, and common exemptions that impact franchisors and franchisees are the administrative and the executive exemptions. I'll briefly touch on one of these exemptions in one area where we find many employers struggle, and that's the working manager. I'll also flag another regulatory issue for you to be on the alert for, and that's potential changes to the exempt salary threshold under the FLSA. So here's a quick outline of the FLSA test for the executive exemption. I won't go over into this in like major detail, but I'm just going to highlight a few areas where we tend to see employers struggle. So first, employees have to be paid on a salary basis. This means that employees must receive a predetermined amount of compensation each pay period that's not dependent on the quality or the quantity of work. With a few exceptions, this amount can't be reduced based on the amount of work that they perform. And there's some other considerations to be mindful of. I can share with a couple of examples. So for example, docking a manager's pay because they're late could result in the position being misclassified, or it could even jeopardize their exempt status. And just because someone is paid a salary instead of an hourly wage doesn't necessarily mean that the position is exempt from overtime requirements. Primary duty must be management. So while managers can work side by side with employees, if too much of their time is spent performing non-managerial tasks, or if they're too closely supervised, then again, that might be a case where they're misclassified. They must customarily and regularly direct the work of at least 2 or more other full-time employees or equivalent. So that might be 4 employees who work 20 hours a week or 2 full-time employees. They must have the ability to hire or fire, or the suggestions and recommendations as to hiring, firing, advancement, whether they get promoted, or any other change of status to their employees must be given particular weight. So again, just one example of sort of that list of considerations that you want to look for. And again, how at Paychex, we work side by side, going through these checklists to evaluate the classification of workers and assist. If you can go to the next slide, please. So as I mentioned earlier, we're closely monitoring potential changes to the exempt salary threshold under the FLSA. So key areas in the proposed overtime rulemaking subject to go into effect are that the salary threshold for the executive, administrative, and professional exemptions increase would go from $684 to $1,059 a week. Could be higher in the final rule. We're still waiting. Compensation requirements for the highly compensated employee exemption increases would go from $107,432 to $143,988. That's $143,988. And then those earning thresholds would update every 3 years. And again, like I said earlier, some states have requirements that are more onerous than the FLSA. This can include a higher salary threshold for exemptions from overtime or a regulatory environment that creates higher risk for employers in general. So like the independent contractor rule, it's likely that the final overtime rule will be challenged, right? We're going to wait and see what happens next. And however, aside from the salary, this is a really good time, as Brian also suggested, this is a really good time to do a classification checkup on all fronts. Make sure all your exempt positions are properly classified. Make sure your independent contractors, your employees are evaluated so that you can meet this test under state and federal law. If you want help with that classification process, you'll see a QR code on your screen. Scan it today. We're excited to help you out. So thank you. Again, appreciate the opportunity to join you this afternoon. Michael, I'll turn it over to you.
That was great, Allie. Thank you so much for that. And to both of you and Brian, you know, I think when I'm listening to you both, and just a reminder that anyone who has questions for either Allie or Brian are welcome to put them into the Q&A function. We also have our email addresses on the screen if you'd like to follow up with Allie or Brian or myself after the program. Certainly, please do that. When I listen to both of you, you know, this regulation is certainly a concern, certainly not something IFA was interested in. Brian mentioned our comment submission over a year ago. We were somewhat pleased that the regulation did not institute what's known as an ABC test for independent contractor status. We've seen that most recently imposed through the AB5 law in California that would not only affect the use different types of contractors, but also really reclassify franchisees themselves as employees within a franchise brand. So, you know, that's the good news for the franchise model, but certainly franchises use a whole host of different types of contractors. And when I listen to both of you, a lot of the, you know, you did a great job making the complex regulations seem plain language. And I wanted to ask you both, are there certain types of contractors that are perhaps most at risk for franchises in this context based on the details of this regulation? Allie or Brian, whomever might want to take a crack at that first.
Well, from I think just within the normal franchise context, Mike, it's the categories that I mentioned earlier, right? If the franchise, again, if we're talking franchisor and franchisee, it's those franchisees who are doing the work and they don't have any employees. You know, that type of business is certainly more at risk. And then also the lower investment, you know, franchises, because again, the 6 factors and the 7th additional factor, it's all geared towards, are these franchisees owning and operating a business with the managerial responsibility, the ability to grow their own business, you know, all of those things that we commonly think about as inherent in franchising, those are there rather than more of the control of the smaller investment, smaller businesses.
Great. Thanks, Brian. A question in the Q&A is...
Sorry to interrupt, Mike. You're exactly right that the DOL did not adopt the ABC test. So that's a great point. And so that, I think, gives us comfort. But again, they do talk about the ability for a party to control pricing. Well, that's often a key part of some franchise systems. They talk about scheduling, right? And so that's a key part of a lot of franchise systems where a franchisor will have a required scheduling tool. So there's not any one factor that typically will sway this one way or another. And so if you are a system that has, for example, scheduling tools that are required, man, I would make sure that I was looking at all the other factors to how do we distance ourselves from that line, knowing that we've got, some risk, if you will, because that is such a core part of our business. So it's not that you shouldn't do it. It's how do you look at the it's the totality of the circumstances. And that's why it's unique to a lot of businesses. And it's actually a good exercise to go through to say, all right, how can we modify, tweak, change some of this so that we get back to the fundamentals of franchising and the role of our role as a franchisor and the role of the franchisees in operating their own business.
Yeah, I'll just add quickly to your comments, Brian. That's a great example when you talk about systems, right? Because that might be sort of the core methodology that's used inside of a franchise, and therefore, right, you may have to consider other factors. And that if you could actually be creating other risks by like avoiding use of the system, right, for the business. So you just I think that just requires, a lot of additional thinking and consideration.
That's great. Thank you, Allie. So next question in the chat is kind of a punchline question. It basically asks, all of this sounds complex. And so what would you tell a franchisee or franchisor, frankly, who wants to take their chances with this new regulation, and whether they're taking the business risk or otherwise passing on doing an audit of their current worker classification? What's the downside? What are the risks in keeping your head down and continuing to do what you're doing, operating your business under this regulation?
Well, I think the risks, if you get it wrong, are significant. And there's, liquidated damages that are double. So if you've got a group that you have misclassified, and think about this in a franchisor franchisee context. I mean, if we have our franchisees misclassified, that can be that's a deal breaker, right? That can be the end of the system. But again, I don't think it is bite-sized and manageable to better understand these issues and how it plays out in franchising by just talking to folks and looking at your business and what can we do to reinforce, that these franchisees are in business for themselves. They're independent owners, and we're going to provide tools and resources and brand standards and not do the business for them. So when the lawyers talk about the legal stuff, it can get complicated and mushy. But I also think when you think about it from a business perspective, it's a little more manageable.
Yeah, I'll just add, at Paychex, right, our HR business partners are working with our customers, and we're going through that checklist, and it's plain language, right? So we turn it into a conversation so that it's not scary, it's not complex, right? So, my advice to the franchisee who wants to take their chances would be to call me to, help them understand that just by talking to an expert, I think they find that they could really see how they have some opportunities to mitigate risk and protect themselves and the brand.
And I think a lot of franchisors, Allie, right, will have Paychex and others, but Paychex as a preferred vendor or supplier available to their franchisees. So that's a great point. If I'm a franchisor, that would be one of the preferred vendors that we would have for this very reason.
Mm-hmm. Absolutely.
Great. Well, there probably aren't a lot of one-size-fits-all solutions here, so we do need experts like Brian and Allie to work with to help navigate these changes to law. And I will note, maybe as we close here, that there is a business coalition that has brought a legal challenge to the rule. So even though the rule was effective, the independent contractor regulation was effective on Monday, there is some potential, like the joint employer rule, that it could be struck down, but that is not the case where we sit here again on March 14th. So that's why we need this program. So I'll just close with that, and we'll let that Allie and Brian's final words be that. And I just want to thank both Allie Stevens of Paychex and Brian Schnell of Fagery Drinker for their expertise and participation in today's program. Thank you, everyone else, for being a part of today's show. And please contact any one of us offline for additional questions, and if we can help you and your system navigate the independent contractor regulation in any way. That's all we have for today. Thank you, everybody. Enjoy the rest of your spring Thursday, and we look forward to the next program with you.